For the last few years, you've probably been using something called the EU-US Privacy Shield, which was developed to provide reassurance to European customers that American companies could be trusted to take care of EU citizens and residents' personal data. Now, an Austrian privacy campaigner by the name of Max Schrems was concerned about the transfer of European customers' Facebook data back to the US and initiated a court case which led to the Safe Harbor Agreement being ruled invalid in October 2015, 5 years ago. The US Department of Commerce, working closely with the European Commission, prepared a replacement known as the Privacy Shield. That arrangement requires American companies to annually self-certify that they meet the requirements of the Privacy Shield and to display a privacy policy on their website. According to Schrems, the provisions of the Privacy Shield were not strong enough to protect European personal data against the reach of the US National Security Agency and its mass surveillance of private data belonging to European citizens as revealed by the many disclosures of Edward Snowden. In May 2016, the GDPR was passed in all EU member states, allowing a 2-year period before enforcement would begin. Max Schrems established a non-profit privacy foundation known as None of Your Business, and as soon as May 2018 arrived, he initiated a court action to test the compliance of the Privacy Shield against the new regulation. On July 16, 2020, there were 2 major issues for the court to decide. 1. Can the EU's standard contractual clauses, SCC also known as model clauses, continue to be used as an adequate transfer mechanism for the transfer of personal data from EU member states to third countries, i.e. outside of the European Economic Area? And 2, is the Privacy Shield a reliable transfer mechanism for the transfer of personal data from EU jurisdiction to the US? SCCs remain valid in principle according to the court, but only if the data importer can ensure its compliance with EU data protection standards. In other words, to avoid any conflict with GDPR compliance. The problem with this is US surveillance laws. These override any legal protections the US company that is importing the data may apply to protect European residents' personal data. We'll talk about SCC later. For now, the key news is that the Privacy Shield was invalidated with immediate effect. It was simply deemed not fit for purpose and was structurally unable to provide roughly equivalent levels of protection as enjoyed by European data subjects. The court's reasoning was that US surveillance law would always override privacy interests, and whatever promises were made by companies such as Facebook, it could not guarantee that the NSA would not simply ignore the law and continue to carry out mass surveillance of non-US citizens. The court took note of several other mechanisms, including, for example, the data export necessary for the fulfillment of a contract, as being valid to continue transfers. Informed consent freely given may also be used as a valid transfer mechanism, but within certain limitations. So what are the consequences of the CJEU ruling? Organisations who have been relying on the Privacy Shield to authorise their transfers of personal data can no longer enjoy its protection. Specifically, US-based businesses may freely continue to transfer the personal data to the EU, but face an increasing level of risk that transfers from the EU are considered to be illegal. Article 49 allows necessary flows of personal data to continue to flow, but with a different lawful basis. According to the European Data Protection Board, Article 49 GDPR should not become the rule in practice, but needs to be restricted to specific situations, and each data exporter needs to ensure that the transfer meets the strict necessity test. The bottom line is that if you cannot find suitable supplementary measures or safeguards to protect personal data transferred to US processors or joint controllers, then the transfer of personal data, even under SCC, should be suspended indefinitely. Doing nothing is not an option if you wish to continue to send the personal data of EEA residents to the US. The UK Brexit decision takes effect from the 31st of December 2020, at which point the UK will no longer be covered by most EU arrangements, except for those which were specifically negotiated in the transition agreement. In fact, there is already a variation of the Privacy Shield specifically for Switzerland and the UK. So it could be argued that the CJEU decision could simply be ignored by Switzerland and the UK, neither of which are EU member states and therefore not under CJEU jurisdiction. I'd like to see that one argued. The UK Information Commissioner's Office, the ICO, issued a statement on the 27th of July regarding the CJEU decision, which confirmed that for now, the ICO is operating under the guidance of the European Data Protection Board. This guidance recommends that UK businesses carry out a risk assessment, a DPIA, as to whether SCCs provide sufficient protection, whether the transfer is to the US or other third country. If the risk assessment is not satisfactory, then the relevant supervisory agency should be notified. In the event of a no-deal Brexit, the UK would most likely be treated as any other third country and be required to use transfer mechanisms such as standard contract clauses to import data from the EEA. Additionally, there may be an obligation for UK companies to appoint Article 27 EU representatives in countries with whom they have processors or controllers. An additional consequence of Brexit is that the Electronic Privacy Regulation, the planned successor to the 2002 Electronic Privacy Directive, will not automatically become part of UK law. Therefore, the British government would need to make an independent decision about including its provisions in UK laws. So, some recommendations. If you were previously using the Privacy Shield as a transfer mechanism for sending personal data of UK or EU data subjects to the US, you should urgently consider switching to another transfer mechanism and update your privacy notices accordingly. This affects currently around 5,300 US companies which have self-certified with Privacy Shield. You might, in some circumstances, have an obligation to send the revised privacy notice to your data subjects. In addition, you should carry out a new DPIA or refresh that is triggered by the fact you're using a new transfer mechanism. Depending on the nature of your business, you may wish to consider switching to SCCs, or if possible, use the provisions of Article 49 that I explained earlier. Note that binding corporate rules might also be found to be inadequate due to the primacy of US surveillance law. According to the European Data Protection Board, even if you're relying on the SCCs for transfers to the US and taking into account supplementary measures like pseudonymization, additional encryption, reducing the data, etc., a decision to keep transferring data despite concluding that the measures are not adequate should be notified to your supervisory authority.